Hi, everyone. Welcome to today's presentation on emerging high-risk TCPA trends with John Henson of Henson Legal. John's solo practice is focused on TCPA defense and marketing compliance for lead generation, insurance, mortgage, real estate tech, and AI voice. He's a former General Counsel of ConsumerAffairs and former VP of Compliance for LendingTree. A few quick housekeeping points. These slides will be provided in the next day or two during follow-up. Drop any questions into the Q&A panel anytime to be addressed at the end of today's session. And remember, this is education, not legal advice. Before we get started, think about your own opt-out flow, your dialer or voice stack, and your text program. John will map each risk to a fix. And with that, I'll turn it over to John.
Thank you so much. I appreciate it. Thank you all for letting me take part in this webinar, and hopefully you get some good information out of it. I'm going to jump ahead a few slides here. That's me. We just talked about it. And again, these slides are going out after the presentation as well. And please feel free, as she said, to put your questions, comments in the chat or the question and comment section, and happy to answer them as they come up. So we're going to talk today about the Telephone Consumer Protection Act, which is the TCPA. What is it? Who does it cover? And what kind of communications with customers does it cover? One thing that I love about TCPA is how it touches so many different industries and so many different companies across the board. I always like to say that when people ask me what I do, I said I help companies talk to their customers compliantly, right? And that's what the TCPA is here for. And the TCPA has two independent buckets, as I call it, right? One is our regulated technology bucket. And that bucket says that if you're using certain technology, which we call regulated technology, then you have to have a certain level of consent to make calls. And the thing that's interesting about this bucket is it says any call with these technologies require the consent of the consumer, whether it's prior express consent or prior express written consent. So those technologies are what we call automated telephone dialing systems, which is an ATDS. Also think of it as an auto dialer, right? Could also be pre-recorded voicemails. So we all know what a ringless voicemail is, where you call the consumer and it drops a voicemail in their voicemail inbox without the phone ringing. Also, artificial voice calls are covered by regulated technology. And this becomes important for us because, as we all know, everything has to be about AI, and AI voice is also covered under regulated technology. So if you are making calls with an auto dialer, with pre-recorded voice, or artificial voice, including AI voice, you have to have some level of consent before making any calls. And the TCPA puts calls into two buckets, right? So that's informational calls, and those require prior express consent. And then marketing calls, which require prior express written consent. So the difference there is kind of the rule of thumb I give clients is if you're talking to a consumer about money they've already spent, right? So I'll think about appointment reminders. Hey, you have an appointment reminder. Your prescription's ready to pick up. Your car's ready to pick up from the shop. Those kind of text messages or calls would be considered informational. And because they're informational, they only require prior express consent. And that means if the consumer has given you their phone number to call them about the specific thing you're talking to them about, that is prior express consent. So I love to use the car dealership example, right? If I drop my car off to get an oil change and they say, hey, can I call you back at phone number? And I say, yeah, that's perfect. It's the number on the form. Great. That is prior express consent. Now, prior express written consent has a few more layers, and it has to be written, and the consumer has to sign it. Now, that signing can be digital, but nevertheless has to be signed, right? So that is for marketing calls. Marketing calls are going to be calls that I want you to spend additional money, right? So, hey, can I talk to you about your car warranty? John, thanks for filling out a form. Would love to talk to you about homeowners insurance. Would love to talk to you about a mortgage, right? Those kind of things are marketing, and they're going to require prior express written consent. So you'll see this consent is very important because depending on what kind of call you're making, if you're making a call with regulated technology and you are doing a marketing call, you have to have very specific consent. So that is the regulated technology bucket. The other bucket is the DNC list, okay? National Do Not Call Registry. The TCPA establishes the National Do Not Call Registry. And it says you cannot make, quote, telephone solicitations to numbers on the Do Not Call Registry. So what's a telephone solicitation? Essentially, it's a marketing call, right? And there are some carve-outs there. So before we get to the carve-outs, it basically says you cannot call a number on the national DNC list, right, with a marketing call. That is what the DNC rule says. Now, as all good definitions have, they have carve-outs, right? So what's not covered by telephone solicitation? Well, if you have the customer's consent to call them, okay? And that's going to look like prior express written consent, right? Because it's a slightly different definition under the DNC, but essentially it's prior express written consent. Alternatively, you can also have an established business relationship with these consumers. And the established business relationship is defined in the regulations as one of two types. It can be an inquiry-based established business relationship, or EBR, okay? And that's when a customer reaches out and says, hey, I want to learn more about your product or service. They've given you some information, and they're trying to get information back from you. That is the inquiry-based EBR. And that inquiry-based EBR is time limited to 90 days after the inquiry, right? So you have a customer come to you, they fill out, they reach out and fill out a form, and they ask you about your product, and you can call them back for 90 days. A transaction-based EBR is a contract, right? So if they've finished the transaction, you can call them for 18 months after that transaction date. So for instance, if you're an insurance company, right? So you've got an annual renewal that renews every year on that contract date, giving you another 18 months to call them. Now, the important thing to remember for the DNC and the regulated technology is that they are two separate buckets, right? So you have to comply with the regulated technology portion, and you have to comply with the DNC portion. Now, if you're not using regulated technology, you're manually dialing off your cell phone or your office line or whatever, then the regulated technology portion doesn't apply. But the DNC portion does apply. And that's where we see a lot of people mess up. So the other reason the TCPA is very important is because it has a private right of action, meaning for violations, consumers can come in and say, hey, you violated this. You weren't supposed to call me. You owe me a minimum of $500 per call or text, okay? It can go up to $1,500 if the court finds that the violation is willful and knowing. So you can see that this becomes very important for plaintiffs' attorneys, right? Plaintiffs' attorneys trying to sue companies because they are trying to find out how many calls you made that violated the statute, because it magnifies and multiplies so quickly. I like to say $1 million here, $1 million there. Pretty soon you're talking real money, right? And if you're making any sort of high volume dialing, that is a very high volume risk. So we're going to cover three things that are talked about. And the three areas are going to be When is stop not enough? And that is the new revocation rule that's in play. What about AI and outbound dialing? And what about texting versus calling? Okay, so those are the three things we're going to talk through today, because these are the three probably biggest areas that I see in my practice now. And the first one is, when is stop not enough? Revocation and opt-out. Okay, so again, consent, very important in TCPA purposes. Okay, and for that, you have to give them consent. The consumer has to give you consent, but they have to have the ability to take it away as well. And last year, the FCC's new revocation rule went live, and part of it they paused. Okay, but the main part is still in play, and that's any reasonable means. The law says you have to honor any reasonable request by a consumer to opt out of calls or text from your company, okay, if you're calling. Now, that can be text message revocation, that could be on the phone with the consumer, that could potentially be email. The problem is they have stated any reasonable means, so you've got to be able to identify, is this a reasonable request? And they've shrunk the requirements from 30 days to 10 business days to honor those revocation requests. And in a text message situation where the consumer sends you a text back, you have to honor all 7 of these keywords. That's going to be an immediate revocation. Stop, quit, end, revoke, opt out, cancel, unsubscribe. Any of those 7 in a text message back to you is a requirement for automatic putting that consumer on the DNC list. Excuse me. Now, we're already seeing some lawsuits testing this, right? There was a couple of lawsuits filed, I believe, in Florida, where the customer replied S back, okay? And they kept sending text message. And they said that the sending S was them trying to say stop. And the caller said, hey, that's not reasonable. We can't know what you mean when you say S, okay? So that becomes what I call non-standard request. How do you make sure, especially if you're calling at a high volume of calls, how do you make sure that those non-standard requests are being honored? Take me off your list. Stop texting me. I never signed up for this. Leave me alone. Remove this number. Not interested. Don't contact me. Most of these seem like reasonable requests. I would actually question them. I never signed up for this. That's not telling me don't call them back, right? But is it reasonable to assume that they still want to be called if they said, I never signed up for this? Maybe, maybe not. Probably not. That seems pretty reasonable. And the problem is on this, that it's up to the caller to say, hey, they said, you guys text a lot, and that was the response back, right? Is you guys text a lot? Is that a reasonable request? No, right? Is now's not a good time a reasonable request to be put on the DNC? I would argue no, because that implies that there would be a good time to call them, right? So that's when this becomes difficult, is making those judgment calls. So that's one area that we want you to start thinking through, of like, how do we address these requests with our clients and make sure that we're not texting people who don't want to be texted. Sorry, I'll put the button again. There we go. So this keeps moving, and I said not all of it was paused. No, some of it was paused. One of the areas that's paused was, if I respond to a transactional text message, should that take me out of marketing text messages? Or if that takes me out of marketing text, or if I opt out of marketing, does that take me out of informational text messaging? So that is the rule that was paused. What's live right now is the reasonable means and the 10 days, okay? The revoke-all was supposed to go into effect in April 2026. That is that has been paused until Jan 31 of next year. Most people feel that there will be some changes to that from the FCC over the next 6 months, and that revoke-all probably not going to be implemented. But the main thing to keep in mind right now is that reasonable means in effect, 7 keywords in effect, 10-day time frame in effect. What to do for you if you are texting or calling customers and you want to make sure that you're honoring opt-outs better is you have to have a way to catch natural language, right? You have to understand when someone sends you a non-standard response, because you not being able to process that is not a defense for violating D&C claims, okay? Also, you want to have a central D&C list that you know the people on this list have given us consent. We can call these people. The people on this list, we cannot, okay? You also want a good audit trail. You got to be able to prove on June 25th, you told me not to text you. We took you off the list on June 30th, right? So you have to be able to show when that happened. And then your vendor flows are very important as well, right? So if you're buying leads or you have a vendor who's handling your SMS and dialing campaigns for you, you need to make sure that your contracts are right and that they're handling the opt-outs as well, okay? So those are kind of 4 key takeaways for you today on that revocation rule. Next, let's talk about AI and outbound calling. I will tell you that this has become probably almost half of my practice now, is this AI and outbound calling. I see a question, sorry. This is a great question about opting out, right? If I run an insurance agency like Bob Smith Insurance for Allstate, and a consumer opts out of Allstate communications, does that mean I have to stop texting them too? That is a great question. So the consumer is opting out of receiving communications from that person. If it's reasonable for them to pass that information on to an affiliated company, then you probably should stop texting them. Now, for example, I would think you also have to take the context of the revocation into account, right? So if I'm text Bob Smith, or if I get a text from Bob Smith Insurance, and I say, I don't want to hear from Bob Smith anymore, that's probably just a revocation of Bob Smith, and Allstate could still probably contact them. If I am known as Bob Smith for Allstate, and all my text messages say Bob Smith for Allstate, and I unsubscribe from Allstate text messages, probably should unsubscribe from Allstate, from Bob Smith Allstate. I would have a different opinion if you were an independent agent with multiple carriers, right? Because at that point, if I unsubscribe from Progressive, right, text messages, that doesn't mean I'm unsubscribing from the independent agent there. So that's a good question, and you've got to take into context what's the consumer responding to, how's the consumer saying that, and then moving forward, what would the consumer be thinking that they are opting out of? So AI voice, like I said, huge part of my practice. In February 2024, the FCC came out and said, hey, when the TCPA says artificial or pre-recorded voice, that includes AI voice. And, you know, I like to say, that's something we should have all known. It's right there in the name, right? It's artificial intelligence voice, but it is covered under that. So what does that mean? So it makes it a regulated technology, right? And so like we talked about earlier about the regulated technology, any call with AI voice has to have some level of consent. If it's an informational call, it has to have prior express consent. If it is a marketing call, it has to have prior express written consent. Okay? So additionally, because it is a artificial or pre-recorded voice, there are rules in the TCPA about requirements for artificial or pre-recorded voice. Those calls have to identify the person at the beginning of the call, both the caller, if it's an individual, and who they're calling on behalf of, right? So, hey, this is John Henson calling from Allstate, right? You also have to have an automated interactive opt-out mechanism, like, hey, this is John Henson from Allstate. To opt out of this, press 2. So that is under the regulated technology bucket. But as we talked about, those are two separate buckets and you have to honor both of them. So therefore, you have to have the DNC rules in place as well, and the time of day rules in the DNC, right? What we call the quiet hour rules. And just because you're using an AI voice doesn't mean you don't have to honor those. We also see a lot of people think, hey, I am using AI voice. I have an established business relationship, therefore I can call them, right? That's not the case. That happens a lot. So why is AI voice a class action? Okay, that's a great question as well. And one of the things, and we've already seen it, there's a case with a mortgage company going on right now that a lead generator used AI voice and said, hi, would you like to save money on your mortgage? And if so, call us and press 1, right? Consumer press 1, talk to a live mortgage person. Problem is, the mortgage company never had the person's consent, and because they were using AI voice, it's created a class action. And they're dealing with this lawsuit right now. And that's one of the points and problems of AI voice, is because one thing AI voice does is it allows you to call at scale, right? And because TCPA is $500 minimum per call, that increases your risk significantly. Also, you see a lot of times that built-in evidence, like AI calls are logged, they're recorded, they're transcribed. We're training on the data all the time, right? And the plaintiffs can go in and pull those records and see those records and make sure that they are being recorded. Another issue with AI voice is because all the calls are being recorded, that consent to be recorded needs to be present in certain states. Otherwise, you could be violating some wiretapping rules. We talked about consent, and that prior express written consent is a lot stricter than just prior express consent, right? Specifically for marketing calls. You have to have prior express written consent for marketing calls. And are you getting the right consent? We see people miss this a lot, and that they think they may have consent because the customer gave them their phone number at one point. But if they didn't see the right language and consent to receiving an AI voice call, then that causes some issues from the consent perspective, and whether or not that they actually had consent to use AI voice. Additionally, FCC has been very clear. They're very interested in AI robocalls. States are very interested in them. So we're seeing a lot of action in that area, a lot of movement back and forth in that area as well. So we're seeing a lot of AI voice companies just go out and sell this and not think through what it actually means. I will tell you the single biggest thing I hear all the time is, well, we're going to use AI voice to cold call. We can't, right? Because you have to have consent, period. Again, consent is key, like we talked about. Informational is going to require prior express consent as a minimum. Marketing also going to require prior express written consent, like we've talked about. And the purpose of the call is the determining factor, right? So what I mean by that is, If you're a pharmacy and you say, John, your prescription's ready to pick up, okay, that's informational. If I said, John, this is Publix Pharmacy, don't forget Advil's on sale this week for 20% off. Okay, great, that's marketing. It's pretty clear. What about if I said, John, this is the pharmacy, your prescription's ready, and don't forget to stock up on Advil lots, 20% off. That's a blended message, and those are considered marketing. And you have to have prior express written consent for that. Courts look at what you're trying to do. Are you trying to pass information along, or are you trying to get them to come in and spend money, right? So even calls that you may think are informational may not be informational if they're purely marketing. I mean, if the intent is marketing. So additionally, we talked about this briefly, right? Recorded line consent. You have to have consent to call on a recorded line. And that can be as simple as, this is John on a recorded line. That's it. That's all you need to do, right? Most of the states that require it say, by clearly disclosing you're on a recorded line and the other party not hanging up, that is sufficient to be consent there. But it's got to be disclosed. Excuse me. Tying it back to the conversation we just had about revocation of consent, right? If you're using AI voice, you have to have a way to honor and recognize those opt-outs. If you're dialing with AI voice and the customer says, don't call me again, that is a clear opt-out. We see a lot of times that AI voice platforms don't listen to what the customer says and report that back. It's two things. You have to hear it and you have to act on it. And if you're not having a way to tie your voice dialer back to your CRM or your other platform, your CRM or your other platform, then there is a real risk there that you're missing some reasonable opt-outs. Now, earlier this year, there was a case that was decided. A text message was sent by the RNC, Republic National Convention, that had a video in it. When the consumer got the text, they saw the text, but they didn't play the video. Okay, they sued for pre-recorded voice, but it wasn't. It was a text message that had a video. Okay, that is not initiating the call using a artificial or pre-recorded voice. The call was made and there was a voice, and those are two different things. So, but don't think that this legalizes AI voice phone calls. That is not the case, right? This case also doesn't apply outside of the Ninth Circuit, which is California, Washington, and Oregon, right? And it doesn't touch on the fact that text are calls, which we're going to talk about in just a second. So that's one little caveat in an area that's come up about this artificial and pre-recorded voice lately. But again, super narrow, doesn't apply to most people. So what do we do about AI voice, right? Okay, we need to treat every AI call just like we would if we were using an ATDS auto dialer, right? So confirm we have prior express written consent for our marketing. Confirm we have prior express consent for any call. Don't cold call with AI voice, okay? Make sure we've got the right disclosures there, okay? Are we saying that we're a pre-recorded voice? Are we identifying who we are? Those kind of things are going to be required of AI voice, and we've got some state laws around AI voice, which may or may not require that the AI voice is disclosed, right? That you're talking to an AI, not a person. Again, we want to follow our DNC rules. We want to make sure we're not calling anybody that we cannot call because they're on a DNC, because they're on whether it's the national DNC or an internal DNC, which are two different things. Got to make sure that we're suppressing who we're supposed to be suppressing, and we're not calling during quiet hours, right? you've got to understand what your vendors are doing by default. Okay? How are they setting it up from a compliance standpoint? You got to do a good job of vetting your vendors. Ask them how they're doing their job from a compliance standpoint. I always tell my clients that are looking at vendors is I don't want your vendor doesn't necessarily have to know chapter and verse of TCPA, but they have to be confident in what they're disclosing. So double check your vendors and make sure they're doing things the right way. So is texting a call? Yes. However, we are seeing a lot of lawsuits in this area right now. So again, looked at the Howard case earlier. Text messages are calls under the TCPA. Okay. So consent, revocation, opt-out, D&C obligations all apply to SMS campaigns just like they would to phone calls. Okay. Now, there was a case that came out this week that the plaintiff claimed that they got a pre-recorded text message. And the court said there's no such thing as a pre-recorded text message. It's pre-recorded calls. And that is not the same. So we're seeing a lot of movement in this area and a lot of changes based on the states. So that is one thing that I would want you to be cognizant of there, is that there is some difference of opinion, but general consensus is right now, text messages are treated exactly the same as calls, right? And again, because they're treated the same as calls, $500, $1,500 per message math, right? You still got to make sure you're honoring your internal D&Cs. The consent language has to be right. Revocation has to be done still correctly. So that are the things we're looking at. And it suddenly has become an open question because of partly the Supreme Court. So you may remember a couple of years ago, we heard a lot of talk about the Supreme Court Loper-Bright decision. And Loper-Bright said that the Chevron doctrine that courts have followed for years, which was deferring to federal agencies instead of the courts making the decisions, they deferred to the federal agencies. That got overturned by Loper-Bright. The next year, the court looked at a case called McLaughlin, and McLaughlin looked at the TCPA and the FCC's level of deference that courts are supposed to give to the FCC specifically, because the FCC, very legally boring, but FCC was also given what we call Hobbs Act deference, which was above and beyond Chevron deference. But nevertheless, McLaughlin said, no, that's not accurate either. Courts get to make those decisions about what words means in statutes, not the FCC. So basically what this means is for the last 20 years, everything we thought we knew about the TCPA is now up in the air. And you're seeing it in several areas. Texting is one of these areas, right? Another one of these areas is the Fifth Circuit, which is Texas, Louisiana, and Arkansas, I believe. Don't quote me on that, though. Has said, hey, marketing text or calls don't require prior express written consent. They just require prior express consent, okay? That is a narrow holding in a narrow state, in a narrow district. Get prior express written consent, okay? That's the same thing I tell clients about text and calls. They say, well, I hear courts have said that text aren't calls. Well, there are some, okay? But they're district courts, first of all. They're not the whole circuit, which means they don't apply in the entire circuit. They just apply in that district, right? So far, I think it's just a couple of districts in California. I think there's a district in Florida. A district in Texas and a district in Florida. Not a lot of districts there. Now, the Seventh Circuit has heard argument about this, And if they come back and say, actually, texts are not calls because the FCC doesn't get to declare that, only Congress can, then we have a circuit split. And then that's how this gets resolved, right? So there's a lot of things to say. Treat text as calls, okay? So what does this mean for your SMS program? It means treat text as calls, right? So get consent, follow the DNC rules, follow the revocation rules. DNC applies is going to apply to SMS. Scrub your internal DNC. Scrub your the national DNC for text. Revocation rules, like the first thing we talked about, right? You got to honor those reasonable means. You have 10 days. That all has to be done today. Again, pay attention. Get good TCPA legal counsel. They can advise you on where the state of the law is for where you're sending out text messages. Oh, sorry, clicked the wrong button here. So how do we practically do this? Okay. One is from an operational standpoint for TCPA purposes, don't treat voice and text different, right? Don't think, oh, text is different. We'll do this separately. Then we make sure we have consent for our voice stuff, because that just doesn't work. If you revoke consent on text, then apply to text. If you've asked to be put on the do not call list, put them on the do not call list. All of those policies should be treated the same. Document the consent for each number. And this is super important, right? You need to be able to say, I'm calling John Henson at this phone number. I got consent to call him at this phone number on this date. It came from this website, and this is the information. This is what he consented to, right? The reason that's important is, especially if you are running different campaigns, meaning marketing campaigns like inbound, and you're getting some information from a lead vendor, and you're getting some information off a Facebook form field. You want to be able to show, hey, he came in through a Facebook form field. Here was the language he saw. And you're going to abide by that consent language, right? One thing I see people do is they'll have a campaign running that says you agree that we may call you on this phone number, okay? About whatever, like let's say life insurance. And they say, hey, we got all this consent language. Can we use AI voice to call them about car insurance? Well, maybe not, right? Depends on what the consent language says. Because if it was as simple as I just said it, no, they consented to get phone calls about life insurance, not AI voice calls about car insurance, right? So that's why it's important what that consent language says. You want to leave it, you want to give yourself as much optionality as you can in that process. So we've got our unified text and voice rules. We're able to document the consent, and we know what we can do with every phone number in our book. Now we're going to scrub against every time we send out a text, right, in national and internal DNCs. Now, the one thing about TCPA consent, which we haven't talked about yet, is the statute doesn't say that consent goes away unless the consumer revokes it, right? So I always have clients like, hey, I've got consent from 3 years ago. Can I call them? Yeah, actually you can. Now, we want to mitigate some of that risk. And one reason we want to do that, how we want to do that, is by scrubbing the DNC, making sure that nothing has popped up. Two, this is an area that people miss, is scrub against the reassigned numbers database, right? So there's a database of numbers that have been reassigned. I want to say the last time I heard it was 3 million numbers get reassigned every year, change hands. So consent you got 3 years ago may not be for the right person, right? People move, people change their phone numbers. So that's another area that I think we should be looking at too. Then build to flex there. We want to make sure our program is flexible, right? If we have the ability to, only rely on prior express consent, or the court says texts don't apply, then we want to make that to be flexible for us, that we can respond accordingly, not just rely on a complete rebuild of the system here. So again, what's happening is, much like everywhere else, the regulators and the regulators are kind of trying to figure out where we live in this new world, right? As we've made this shift from residential home lines to, I think a majority of people don't even have home lines anymore. I think that was the last stat I said, is that we've almost moved to where majority of people don't have home lines. The laws written, such as TCPA, in a time where we all relied on home lines, is we're trying to make those fit, right? TCPA was first written in 1991. The world in telecommunications looks wildly different now. And so these three areas that we've talked about today, revocation, AI voice, and texting, are all like, how do we handle this new world of communication using this old statute? The regulators are slowly catching up, but the lawsuits aren't stopping, and they're not waiting for them to stop, right? So we want to make sure that we are both following what's going on with the regulators and following how the courts are handling these lawsuits, and what are the plaintiff's attorneys doing and trying to fix, right? Or trying to fight about. That's the kind of things that we want to think through as we're building this, as you're building your TCPA program. I've got a couple of questions. Give me 1 second. Here's one good one here. How does this apply to getting 10 DLC approved? Sometimes people tell me they have a hard time getting 10 DLC approved, even when they're TCPA compliant. Very good question. I'm having to deal with this a lot lately. So 10 DLC is text messaging, SMS messaging on platforms, right? Also, like, it's related to short codes, things like that. So the FCC controls the carriers. You have to understand how this all fits together. They tell the carriers, hey, these are your guardrails here. And the carriers go down to their partners and they narrow those guardrails, right? And their partners like Twilio, Five9, any other dialing platforms. Those carriers and those platforms then go to the user, which would be like you as a company trying to send text messages. Then the users are in even narrower lanes. So when I have customers that are struggling with 10 DLC issues with their partners, what we generally see the partner saying is, yeah, your stuff is TCPA compliant, but you may not be fitting with the CTIA regulations, right? That is a popular fallback for those companies. The CTIA regulations, best practices, deal with what the consent should look like. They want a checkbox, even though a checkbox is not required by law. There's certain areas that CTIA wants to make sure that your privacy policy is covering, that you're not sharing information with third parties, things like that, right? So it's not just a TCPA compliance thing, it's also a CTIA compliance thing, and it's just creating additional hoops to jump through. And that is something that I am seeing quite a bit of. So that's a very good question. Another question here. Certain states require a number of agents for telemarketing registration fees. Yes, they do. How many agents should be put down for a company that only uses outbound AI bots for their campaigns? Would it be 0 agents? That's a good question. It's also very specific. I probably would not. Put it this way: depending on the state, I probably would not put 0 down. I'd probably put at least one person down. For lots of reasons. But one is, again, it's optionality, right? Like if you put 0 agents down and a human at any point is involved in that, then you're wrong, right? And then also if you're also setting yourself up for an argument with the state. I will say, generally speaking, I'm thinking of like 4 states right now that have pretty strict telemarketing registration rules. All 4 of them are pretty easy to deal with from a filing standpoint. So you call, ask them questions, they'll answer them. So that's pretty helpful. I wouldn't be comfortable putting down 0 because at that point, no human could ever answer the call there. So good question, very specific. I like it. Sorry. So we've talked today about some high level stuff. Obviously, if you have any questions, I'm more than happy to help. You can find me on LinkedIn. You can find me online. I'm pretty easy to find. And if we have any other questions, here's my email address as well. If you have any other questions, happy to take any other questions right now. Oh, looks like I have. Oh, no, those are just the ones we've already answered.
Looks like we're good here, John. I don't see anything else. I think we had some really good questions, and I hope this has been informative for everybody. Again, we'll be sending out slides for follow-up here within the next couple of days.
Great. Thank you so much for the opportunity, and hope you all have a great rest of the day.
Thanks, you too.